Thanks everyone. Thanks for coming today. I'm Emily Mann. I'm the program manager in the forensic division in behavioral health and recovery services, which is underneath Health and Human Services with the County of Marin. I've been with the county really just a little over a year. So I have been learning about the CARE Act and about CARE Court. And so we have a PowerPoint slide deck presentation for you today. And I'll also be asking Darren and Molly to chime in with any additional information. And between the three of us, we should be able to answer any questions that you have. And so we'll ask that you hold your questions until the end. We've left plenty of time for Q&A. So like I said, we've got a brief PowerPoint that we'll go through and then have plenty of time for questions. So with that, let me share my screen and get it in the right mode here. Okay. Let's see. Oh, I might have to stop for a second. Hang on. I should get it into the slideshow mode first, I think. Maybe not. Hang on, hang on. Because when I share it, the thing that I need to access gets covered up. There it is. Okay. All right, here we are. Does this look good? Okay.
It's
Yep.
on presenter mode. Yep.
Okay, great. All right, and let's just make sure this works to go to the next slide. All right, very good. And then let me just move myself around because I can't see. All right, so now I can't see any of you, just disclaimer. Okay. So this is an overview of the CARE Act. So the CARE stands for Community Assistance, Recovery, and Empowerment. The purpose is to provide services to Californians living with specifically untreated schizophrenia, spectrum, or other psychotic disorders. It's a civil court process. The court process is collaborative and it provides the individual with a care plan that includes clinically appropriate and community-based services and support. And as Miriam mentioned, we will be implementing CARE Court in Marin County on December 1st. So this is our overview of just real general what the CARE Act is. Next slide. So who is eligible for care? And again, Molly and Darren, jump in anytime. Feel free to interrupt me. Okay, so you'll see over here on the left is eligibility criteria. So folks need to meet these criteria over here. So 18 years or older, a primary diagnosis of schizophrenia, spectrum, and other psychotic disorders. So that's a narrow qualification. The individual has to not be clinically stabilized in ongoing treatment. The care plan or the care agreement would be the least restrictive alternative. So there would be some evaluation in that process as well. And the person we need to believe that the individual is going to benefit from a care plan or a care agreement. So folks for CARE Court have to have all of those things. And then over on the right hand of the screen, at least one of the following. So all those things plus unlikely to be able to survive safely in the community without supervision or without their condition deteriorating, or the person needs the services in order to prevent a relapse or further deterioration, such as grave disability as defined in section 5150 of the WIC code. I think something that's most notable here on this slide is that we're not the ones making the final decision about eligibility. The judge is going to do that. So BHRS is not going to be the one making the decisions around who is eligible for CARE Court. We don't have a lot of flexibility there. That's going to be a court judge function to fully determine eligibility for care. So the next slide is who is eligible to petition. So who of you, the public, the county, the court, can initiate this process for an individual into CARE Court. So you'll see over here on the left-hand side, so from the public, so this includes y'all, People who live with we're saying participant, it's formally called the respondent. So I might use those terms interchangeably. So someone who lives with someone who might need services from care, a spouse, a parent, a sibling, grandparents, anyone with guardianship. The respondent themselves can, in fact, petition. First responders, this is an interesting branch out. So police departments, firefighters, MCRT, homeless outreach workers, basically anyone who is having repeated contact with an individual who might benefit from the care services. Hospitals, charitable organizations, and licensed behavioral health professionals. So there's quite a few categories from the public who would be able to petition for care court. So from the county, and some of these might seem like a little bit of a crossover, but like in the public, a licensed behavioral health professional, for example, might be a private therapist. So then moving over to the county, we also have directors of BHRS, or some of us that work for BHRS, the public guardian, the director of APS, that's Adult Protective Services, all sorts of other folks in the county, Indian Health Services, and judges of a tribal court can also petition for care court. And then of note down here is the court can also refer folks for care court. Assisted outpatient might be an option as a step up from care court. LPS hearings possibly as a step down, and then misdemeanor proceedings as diversion. So care court might be considered an alternative mechanism to try to reach people, to engage them in services. But I think, again, notable on this slide regarding the court is that if there's going to be a step down or a step up, again, that's going to be a court decision. That's going to be something that the judge determines.
Just to quickly clarify, the LPS hearings, care court would be a step down from LPS hearings as far as the level of care required to keep the participant stable, and assisted outpatient treatment care would be a step up. So they would need a higher level of care than assisted outpatient treatment could provide them.
Thanks, Molly.
Mm-hmm.
Okay, the next slide. So here's just a little bit of a snippet of what the process is like. So step one is the petition process, which we just reviewed a little bit. The petition is filed with the court. It's reviewed. There's then a process where BHRS does an investigation to assist with eligibility criteria. And then there's a hearing. The hearing is set, or the petitioner receives a notice of dismissal. That's step one. That can take up to 1 to 3 months. And the reason for that is that during the petition, and in fact in step two, there's a lot of robust outreach and engagement going on, because really the ideal situation would be that we would be able to establish rapport with the individual and potentially get them into services voluntarily. So that would be great if that's possible in some cases. So step one and step two can take between 1 to 3 months in each phase. So then step two here is the creation of either the care agreement or the care plan. And that's when we would start to engage the individual in services after it's been determined what services they need and whether they're going to be in care or whether they might voluntarily engage in services elsewhere. And then the court process in this step two is that there's an initial hearing, and things included in that hearing are around the merits of the petition, what the case management might look like, and things like that. So step three is the support part of the services. So all of that outreach and engagement continuing, working the treatment plan, checking in, reporting back to the court, the participant is engaging, and hopefully making good progress. And that there, it says that can be a 12 to 24 month process. And then a graduation. So that's when a plan is created and the person successfully graduates from care, having received the services that they really needed.
Emily, one thing I was just going to mention, I think all of us would like that process that you just mentioned to be a little bit faster and expedited. The limiting factor we really have, as much as that it's about engagement, there's a limitation in terms of the court and their ability to schedule on their calendar. So a lot of the hearings, there's multiple hearings that are in the legislation that we need to get through from a sequential standpoint, and those are sequenced out, within the next 14 court days. There's time to do investigations and clinical evaluations as well. So ideally, to your point, we can get folks engaged quickly, but if respondents are following the court process, there's just a number of things that are written into the legislation that we don't have control over at the county or even the courts because they're mandated. So.
Yeah, that's a really good point. I agree. I would definitely like so many of our processes to move a little bit more quickly, and sometimes there's just reasons why that can't be. Thanks, Darren. Okay, so the next slide here. So the care petition. So the petition itself, which we already talked about, what it is, who can petition. So there's a form. It's the Care 100 form. It can be found on the court website. And also the Legal Help Center in Marin can assist anyone with filing this petition starting December 1st. So that's a really important nugget for everyone here today and in the community, that legal self-help is here to help. Also required in the petition process is documentation to support the eligibility requirements. So all of the eligibility requirements have to be confirmed and then verified for formal eligibility. And that can be done either with the mental health declaration form, which is the Care 101 form. And that's a form that behavioral health is involved in, for example, to make sure that it's the proper diagnosis, let's say. Or if a family or a loved one or the petitioner wants to bring in evidence that was within a fairly recent period of time, that can be a supplement mental health declaration. But I think what's important to remember here is that both of these documents are required. So knowing that the process can't start just with the submission of the petition, there also has to be this, the forms and the documents that are verifying the eligibility. Molly, Darren, anything to add there? Sorry, I can't see you, but.
Yes.
Sure.
Go ahead, Darren, if you.
No, go ahead, Molly.
Okay. So with this, the Care 101 is the mental health declaration that is required to be filed with the petition. So this documentation, it's essentially what it's doing is giving the court the diagnosis. So the diagnosis of schizophrenia or another psychotic disorder. It's giving them confirmation. So that's either that they have been diagnosed elsewhere or they've been diagnosed within behavioral health. We're providing that diagnosis. Or there's evidence that they have been detained for 2 periods of intensive treatment, which is a 14-day treatment. And one of those intensive treatments has to have happened within the last 60 days. So if you don't have a clinical diagnosis that you can provide the court, then the other thing that can be provided is the evidence of hospitalizations. And this is something we don't have any control over. This is written within the statute, and this is what the judge requires in order to make that determination that the person would be eligible for the program.
Yeah, thanks, Molly. Okay. Next slide here. So petitioner responsibilities. So there is some responsibility beyond just petitioning with the initial process. So you would obviously complete the petition and file it with Marin Court's Civil Division. The participant is then served a notice to appear in court. They'll be provided a copy of the petition. And I think that's pretty important to consider, because if you're a loved one filling out a petition and then gathering the supporting documents, you just might want to be mindful about what you're including in the petition, knowing that the person you're hoping will receive care will get a copy of the petition. So then after that, there's work with the courts or BHRS for questions around the petition. And then at that point, the petitioner will receive a notice of dismissal or a notice to appear for the initial hearing. Then the petitioner would attend the initial hearing. And in some cases, if the petitioner does not attend, the court may dismiss the petition. So there is some responsibility of being the petitioner beyond just filling out that initial form. So we wanted to make sure everyone is aware of that. And then there's just this little graphic down here, a snippet with some timelines to it. And I'm not going to read through this, but I'll make sure, I think that Miriam will be able to send this slide deck out to everyone. So you'll be able to have this little chart here for reference. Okay, next slide. So ongoing role as petitioner. So at the initial hearing, the court will order BHRS to take the place of the original petitioner as the substitute petitioner. So that's something important, just to make sure that expectations are leveled, that is part of the process. Also, the judge will decide if the original petitioner will continue to receive notices for future hearings. So these are not just things that are automatic. The petitioner, there's confidentiality, you know, we wanted to make sure again that if you are a petitioner, you have the proper understanding of how your involvement will proceed as the process proceeds. So the judge, the court, will decide if you as the original petitioner will receive future notices for the hearings. And then after that initial hearing, care court is confidential. Hearings are closed to the public. So including the petitioner, you will not be able to attend those hearings. And so future court proceedings with the participant, they would have to request that you participate in that process. So just wanted to make sure that everyone was clear about that. Okay. So beyond being a petitioner, there's also a role in this process for people to be supporters. And again, what we wanted to make sure folks know is that, you know, you kind of think of like, oh, great, like I can really just support this process. And that's great. We need people to do that. But there are guidelines to being in the supporter role. I really like this part. It's a unique role in this process. And it's cool that the participants will have someone to advocate for them around their choices and keep their autonomy in mind. But again, there are some guidelines around being a supporter. So the public defender will inform the participant about their right to choose a supporter. And then the volunteer supporter can be the petitioner or another adult in their life that they trust who is available to do this volunteer advocacy on behalf of the respondent or the participant. And then moving down in here at the lower part of the slide, the supporter will maintain a neutral stance. So that's going to be an important thing to keep in mind. Represent the preferences and the choices of the participant. Utilize decision-making and trauma-informed care as best as possible. So sort of holding a broad kind of holistic approach to this whole process, even though it's a court process. That's what we would prefer from BHRS. And maintain confidentiality regarding anything related to the care process. So it is a volunteer supporter role, but there are some guidelines that everyone would have to respect. And I think there's a little bit more on this. Yeah. So the supporter would need to know about the care process and to be able to also field questions from the participant in case they get confused about the process. The supporter should be able to at least answer the questions or say to the person, I'll find out. The supporter should be able to attend the hearings and appointments if the participant asks you to be there for those. And then help the participant understand and communicate and make those decisions around their preferences in the care process. So this is such a vital role in this process, but we imagine that it could be a challenging role. And so we just wanted to be transparent about that. There's this little asterisk at the bottom that, you know, we take the supporter role really seriously because it's such an important part of the process. And so again, if something is not working in that relationship, the court still has the authority to suggest that a reappointment of a supporter be considered. Okay.
Yes, and one other
Go ahead,
thing,
please.
Emily, that I forgot in this is if there's a conflict of interest, such as the participant is living with the person who would be the volunteer supporter, and that volunteer supporter relies on the participant's housing voucher to keep housing, that would be considered a conflict of interest that wouldn't be, they wouldn't allow them to be the volunteer supporter because the court would see that there would be a direct conflict that the supporter may not be doing what is in the person's best interest because of that relationship.
Yeah, that makes sense. That feels kind of like a dual role type of thing. So being mindful of those sort of ethical edges in being a supporter. Yeah, thanks, Molly. So then there's informal support systems. And I think this is where you, the loved ones and the families, can really come into play throughout the entire process. So other ways to just support the participant, to support this care process is as an informal supporter, attending the care hearings, collaborating with the care team. So the folks who are doing the outreach and engagement, the treatment team, the people who are offering the services, collaborating with that whole treatment team is a great way to support a participant and this process. Transportation, helping people stay engaged, reminding them of appointments, connecting them to the right people if they're having a hard time connecting with the treatment team or vice versa. So these are just really, really important ways that family members in particular can support this whole process. And we just, really just want to highlight that strong support system in this process, advocating for the participant, collaborating with BHRS, is so important. The family and other community support have such an important role in the individual's treatment. BHRS works really collaboratively with NAMI. We've established some family partnership policies to make it easier so that we can all have more streamlined communication on behalf of the participants in care court. So then the care team. So there's going to be a team of people working on the CARE Act and on care court. But again, keeping in mind that with that, there's confidentiality that we all have to keep in mind, and that those hearings, they're closed to the public. Like I mentioned before, individuals, including the original petitioner, they can attend it only if requested by the participant. So we're going to be respecting HIPAA and other confidentiality laws, such as 42 CFR, which has to do with substance abuse records. The participant is going to have to consent to our ability, BHRS and our treatment team's ability to share that with petitioners, supporters, or really, really anyone. So that's part of this process, as it is in most treatment. That being said, the care team, which is, I as the program manager am going to oversee the care team. We'll have a unit supervisor, a psychologist, an outreach and engagement coordinator. So our care team, we want to hear from you though. So if you can communicate and share information with us about your experience with the process or something about the participant, we are all ears and would be more than happy to partner with you on that. Okay, and so again, I think Miriam will be able to send out this slide deck so everyone will be able to have access to this slide and the next one too, that both have some really good resources on them. You all probably know some of the NAMI resources, but then there's also BHRS resources. There's a crisis text line. We have the mobile response, a mobile crisis and response team that can respond to behavioral health crisis in the community. And then this next slide is a really good one. So, and again, you'll be able to access all of these previously recorded trainings and just a wealth of research on the CARE Act and on CARE Court. And so this green underline here should be a hyperlink so that when Miriam sends it out, you should just be able to click it and it'll take you to any number of resources that are available so that you can learn more.